In federal court, delays usually help defendants. So why is Lil Durk refusing one while everyone else takes it? Y'all know we got the breakdown, right? Hit that like button like you like something. Let's go. Here we go. Todd Blanche, the Deputy Attorney General. Then Bilal Esley, First Assistant United States Attorney. Y'all know what they doing that for. They doing that for appeals. We already done went through this a gang of times, so we ain't even waste our time. Anyways, United States of America plaintiff Durk Banks. And this right here says, stipulation regarding requests for 1, continuance of trial date, and 2, findings of excludable time periods pursuant to Speedy Trial Act, which basically comes out to mean that Durk is still trying to continue on. But here's where it get real eyeball, because it says current trial date is scheduled for January 20th, 2026. Proposed trial date is literally May 4th. You know, for all you Star Wars fans, May the 4th be with you, 2026. Plaintiff United States of America and defendant DeAndre Dontrell Wilson, defendant Wilson, both individually and through his counsel of record. Craig A. Harbaugh, defendant David Brian Lindsay, defendant Lindsay, both individually and through his counsel of record, Robert A. Jones and Tillett J. Mills, and defendant Asa Houston, defendant Houston, both individually and through his counsel of record. Shafi Moi, the stipulating defendants hereby stipulate as follows. The first superseding indictment in this case was filed on November 7, 2024. Defendant Durk Banks, defendant Banks first appeared before a judicial officer of the court in which the charges in this case were pending on November 14, 2026. The Speedy Trial Act, 18 U.S.C. 3161, originally required that the trial commence on or before January 23, 2025. Defendant Wilson appeared before a judicial officer of the court in which the charges in this case were pending on November 15, 2024. The Speedy Trial Act, 18 U.S.C. 3161, originally required that the trial commence on or before January 24, 2025. Defendant Houston first appeared before a judicial officer of the court in which the charges in this case were pending on November 21st, 2024. The Speedy Act originally required that the trial commence on or before January 30th, 2025. Defendant Lindsay first appeared before a judicial officer of the court in which the charges in this case were pending on November 22nd, 2024. The Speedy Act originally required that the trial commence on or before January 31st, 2025. Mind you guys, we are in 2026. On November 14, 2024, for defendant Banks, the court set a trial date of January 7, 2025. On November 15, 2024, for defendant Wilson, the court set a trial date of January 7, 2025. On November 21st, 2024, for defendant Houston, the court set a trial date of January 14, 2025. On November 22nd, 2024, for defendant Lindsay, the court set a trial date of January 14, 2025. On January 2nd, 2025, the court continued the trial date to October 14, 2025 for all defendants and made relevant excludable time findings under the Speedy Trial Act. After reading that, here's what actually stands out, and it matters more than people realize. This document, it's not about guilt or innocence. It's about time. Every defendant in this case had a speedy trial clock that was already running, and the court already moved the date once. Now the government, along with 3 other co-defendants, is asking to push it again, all the way to May. But buried in the language is the key detail. Lil Durk does not agree. He didn't request this delay, he didn't sign on to it, and he isn't asking for more time to prepare. The only reason his trial clock is even being discussed is because the law allows time to be excluded when defendants are tied together in the same dang case, even when one of them objects. And that's where the tension really starts. Because when the government says the case is ready, but still asks for more time, and when a co-defendant says they need months, but Durk says, man, set it up, let's go. That's not fear, that's pressure. This filing doesn't show a defendant trying to run out the clock. It shows a defendant refusing to let the clock be used against him. No speeches, no statements, just a position on record. You charged me, you set the date, now prove this shit. And this is where the case moves forward. That posture is going to matter, because when trials aren't won on vibes or narratives, they're won on evidence under deadlines in real court. So I want y'all to understand, Durk is saying, I don't think y'all got what y'all got, and y'all think y'all got what y'all got. Y'all still trying to prove it. Just like we could prove today's sponsor. Bam. Yep. Speedy, cash. No, real cash. Yeah, free cash. All cash. Yo cash. Free cash, man. Hit this QR code real quick, man, or tap the link in the description, and you know you can win. Nobody has jumped on here and said, I didn't win. The only complaint I keep on hearing is how much money you didn't win. But y'all play like 10 minutes worth of games. You know, PlayStation 2 days and PlayStation 1 games, that was like the dang loading screen about 10 minutes. So play a couple of games, spend an hour or something like that. Listen to this in the background, hit that QR code, and hey, you ain't got a Cash App setting ass nothing. Just say, I appreciate it. Visionaries, we got this one. Click the link in the description, but let's get on to the next one. Roll it. The second superseding indictment was filed as to all defendants on May 1st, 2025. On September 17, 2025, the court continued the trial date to January 20th, 2026 and made relevant excludable time findings under the Speedy Act trial. All defendants are detained pending trial. The government estimates that its case in chief will last approximately 2 to 3 weeks. All defendants are joined for trial, and a severance has not been granted, meaning ain't nobody going nowhere. Y'all asses is all going to be here. By this stipulation, the stipulated defendants moved to continue the trial date to May 4th, 2026. Additionally, the parties moved to set the following pretrial schedule. A. Defendants' reciprocal discovery deadline, March 9th, 2026. God dang, really? Motions in limine, including motions regarding experts. Okay. So, 1. Motions due March 16, 2026. Oppositions due March 30th, 2026. Optional replies due April 6, 2026. Hearing date / pretrial conference April 13, 2026. This is the third request for a continuance. The stipulating defendants request the continuance based upon the following facts, which the parties believe demonstrate good cause to support the appropriate findings under the Speedy Trial Act. All defendants are charged with violations of 18 U.S.C. 1958A, conspiracy and use of interstate commerce to, and it says right here, the parties, including counsel for defendant banks, met and conferred regarding the proposal briefing schedule and deadline set forth below. So y'all got that. So conspiracy and use of interstate facilities to commit murder for hire resulting in death, 18 U.S.C. 2261A to A, B, 2261B1, stalking resulting in death. We ain't even finna go through these codes. We're just gonna say use, carry, and discharge of firearms, a machine gun, and possession of such firearms, and furtherance of a crime of violence resulting in death. Discovery in this case includes, among other things, hundreds of gigabytes of digital evidence, such as audio / video recordings, surveillance footage, and extractions of digital devices, and over 30,000 pages of records and reports concerning murder and other violent acts, photographs, witness statements, and medical documents. Due to the nature of the prosecution and the number of defendants, including the charges in the indictment and the voluminous discovery, this case is so unusual and so complex that it is unreasonable to expect adequate preparation for pretrial proceedings or for the trial itself within the Speedy Act trial time limits. Defense counsel represent that they have various substantive obligations which necessitate the continuance of the trial to May 4th, 2026. The list of obligations for defense counsel is attached hereto as Appendix A and is incorporated as if fully set forth herein. So now we get into what the government is really leaning into to justify this delay. They told the court the second superseding indictment was filed months ago, that everyone is being held pending trial, and that their own case in chief will only take 2 to 3 weeks. And yet, despite saying that trial itself is relatively short, they still asked to push the date back another 5 months. They emphasize that all defendants are joined together, no severance has been granted, and this would now be the third continuance request. Then they lay out a brand new pretrial schedule, stretching deep into April, effectively resetting the clock before a jury ever hears a word of evidence. And here's where the contradiction becomes impossible to ignore. On one hand, the government says this case is massive, hundreds of gigabytes of digital evidence, over 30,000 pages of documents, surveillance, recordings, witnesses, experts, all of it framed as too complex to move forward on time. But on the other hand, they still claim they can present their case in a matter of weeks. That tension matters because complexity alone does not exclude delay forever, especially when one defendant is saying he's ready now. What's this section really showing is not a lack of evidence, but a lack of alignment. The prosecution and some defendants want more runaway, while Durk is refusing to let volume replace proof. And the court is now stuck deciding whether complexity justifies delay or whether readiness should finally be tested in front of a jury. But if you think a little bit harder, how the hell did y'all really prove anything? Just curious, what did y'all truly prove? That y'all have nothing so far, or y'all got too much and y'all trying to scare somebody? To me, it smells like trying to get people to sign plea deals and ain't nobody jumped on it. What y'all think? Let's continue on. In light of the foregoing, counsel for the stipulated defendants also represent that additional time is necessary to confer with defendants, conduct and complete an independent investigation of the case, conduct and complete additional legal research, including for potential pretrial motions, review the discovery and potential evidence in the case, and prepare for trial in the event that a pretrial resolution does not occur. Defense counsel represent that failure to grant the continuance would deny them reasonable time necessary for effective preparation, taking into account the exercise of due diligence. The stipulated defendants believe that failure to grant the continuance will deny them continuity of counsel and adequate representation. I kind of get what they're saying. We ain't all in at the same time, so we can't come up with a game plan. This is kind of hurting everybody here. The government does not object to the continuance. Of course not. The requested continuance is not based on congestion of the court's calendar, lack of diligent preparation on the part of the attorney for the government or the defense, or failure on the part of the attorney for the government to obtain available witnesses. For purposes of computing the date under the Speedy Trial Act by which defendant's trial must commence, the parties agree that the time period from the date this stipulation is filed to May 4th, 2026, inclusive, should be excluded pursuant to 18 U.S.C. 3161. We ain't doing all that crap. Because the delay results from a continuance granted by the court at defendant's request without government objection, on the basis of the court's finding that the ends of justice served by the continuance outweigh the best interests of the public and defendant in a speedy trial. That ain't good for Durk. I'll be honest, this shit getting pushed back like Stephen A. hairline. Failure to grant the continuance would be likely to make a continuation of the proceeding impossible or result in a miscarriage of justice. 3. The case is so unusual and so complex due to the nature of the prosecution and the number of defendants that it is unreasonable to expect preparation for pretrial proceedings or for the trial itself within the time limits established by the Speedy Trial Act. And 4, failure to grant the continuance would unreasonably deny defendant continuity of counsel and would deny defense counsel the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. And this is where the delay request stops sounding neutral, starts sounding defensive. The stipulating defendants tell the court they need more time to do things that normally happen before trial date is set. More investigation, more research, more review, more preparation, all framed as necessities, not choices. They argue without a continuance, they'd be denied reasonable time and even continuity of counsel. And notably, the government does not even object. But listen closely to what's being said here. This delay isn't about a missing witness or a sudden emergency or new evidence just discovered. It's about wanting more time to get ready after months of litigation, multiple indictments, and an already continued trial date. And then the language turns heavy, almost goddamn dramatic. For a reason, the filing leans hard on phrases like miscarriage of justice, ends of justice, and unusual and complex, asking the court to formally suspend the speedy trial clock all the way through May. But that framing only works if everyone agrees that delay is necessary. And that's the tension running through these pages, because while some defendants in the government are asking the court to prioritize preparation over speed, Durk's position quietly exposes the issue underneath it all. Preparation is not the same thing as proof. Volume is not the same as readiness. And complexity does not automatically outweigh the defendant's right to have the government test his case in real time. At this point, the court isn't deciding whether the case is big. Everyone agrees on that. The court is deciding whether big is enough to justify waiting. When one defendant is saying he's ready now, what sense does that make? But I think at the end of the day, Durk ass is in a losing position because there's no way that three of us come out and say we want to push it back. We can't even depend on our lawyers' freaking readiness and all this shit. And then at the end of the video, I'm going to show you something so crazy that the blog sites are going to pick up on it after we mention it here. We might even make a separate video just to kind of, I don't know, muddy the waters a little bit. But let's continue on. Defendant Banks does not join in the stipulation to continue the trial in this matter. Nonetheless, the stipulating parties agree that pursuant to 18 U.S.C. 3161 H6, the time period from the date the stipulation is filed to May 4th, 2026, inclusive, constitutes a reasonable period of delay for defendant Banks, who is joined for trial with co-defendants as to whom the time for trial has not run and no motion of severance has been granted. We go to page 7. Nothing in the stipulation shall preclude a finding that other provisions of the Speedy Trial Act dictate that additional time periods be excluded from the period within which trial must commence. Moreover, the same provisions and/or other provisions of the Speedy Trial Act may in the future authorize the exclusion of additional time periods from the period within which trial must commence. It is so stipulated, dated January 5th, 2026. Respectfully submitted, Todd Blanche, Bill, Bilal A. Esley, Alexander B. Schwab. So, Deputy Attorney General, First Assistant United States Attorney, and Assistant United States Attorney, Acting Chief Criminal Division. Then you got Ian Yanello, Gregory W. Staples, Daniel H. Winger, Assistant United States Attorneys. And this is where the document quietly confirms what Durk's position has been the entire time. Buried in the stipulation, the parties acknowledge in plain black and white that Durk does not join the request to continue the trial. He is formally on record objecting, and yet the filing immediately pivots to explain how the delay should still apply to him anyway. Simply because he's joined for trial with co-defendants and no severance has been granted. In other words, even without his consent, the law allows his speedy trial clock to be paused for the convenience of others. That's not an accusation. That's legal workaround. And it matters because it shows Durk didn't waive anything. He didn't agree to anything. His objection is preserved. Then the government closes the door with one final move, further proving the delay. They make sure the court understands that this stipulation doesn't just cover this pause, but leaves the door open for even more excluded time down the damn road under the Speedy Trial Act. It's a quiet but powerful ask. Not just 5 more months, but flexibility beyond that if needed. And that's the tension sitting at the center of this case. Durk is saying, I'm ready now. The government is saying, we may need even more time later. At this stage, the court isn't weighing evidence. It's weighing rights. And the record now shows exactly where everyone stands when that decision gets made. Because we want to fight. Y'all don't want to fight. But my homies don't want to fight. I'm ready to go to war. What the hell y'all think the court gonna say? Let's go. I am DeAndre Dontrell Wilson's attorney. I have carefully discussed every part of this stipulation and the continuance of the trial date with my client. I have fully informed my client of his speedy trial rights. To my knowledge, my client understands those rights and agrees to waive them. I believe that my client's decision to give up the right to be brought to trial earlier than May 4th, 2026 is an informed and voluntary one. And then you got right here where he signs his name right here. And yeah, but they dated this December 19th, 2025. So look at this. This is last year. December 19th, 2025. Prior to preparation and filing this stipulation, undersigned counsel advised all parties that counsel has a trial currently set for May 4th, 2026 in the United States versus Henley case. Notwithstanding that disclosure, May 4th, 2026 was the only trial date available that accommodated all defendants in this case, and the parties therefore agreed to that date. Counsel notes that in Henley, counsel for other co-defendants, not counsel's own client, have moved to continue the trial, and the court in that matter is expected to rule on or before January 6, 2026. Counsel submits this statement solely to disclose the potential conflict and preserve the court's discretion to address scheduling as appropriate should the conflict remain. I am Brian Lindsay's attorney, and then they right here, but he got his shit signed January 2nd, 2026. So the continuity thing is kind of in our faces right now, because December 19th, for Wilson, that was last year. And then David Brian Lindsay's attorney basically got this signed January 2nd, 2026. I have read the stipulation and carefully discussed it with my attorney. I understand my speedy trial rights. I voluntarily agree to the continuance of the trial, and I give up my right to be brought to trial earlier than May 4th, 2026. Then let's go here. Asa Houston's attorney. And then his is December 28th. Interessante. So he got his, but 28th. Why is his 2018? Your lawyer and you aren't on the same page. Yeah, they might not want to go in with that. And I'm going to be fair, because, hold on. So they saying that this is Big U right here, bro. Hold on. Counsel for defendant Wilson is the same counsel for Big U? What the hell? Wow. And I guess this is their counsel schedule. So he got a trial date May 4th, 2026. And then literally he got some other shit going on August 4th, 2026 and July 21st, 2026. So yeah, this is crazy. And then Lindsay, his damn attorney is basically out of Texas, with the exception of none. All his stuff is in Texas. Fascinating. And this final section is where the paperwork stops talking in theory and starts locking in positions into the record. These pages aren't arguments. They're signatures, names, dates, and certifications confirming who agreed to this delay and why. You can see exactly where defense teams signed on, exactly when they did it, and exactly what they're committing to. Appendix A lays out the conflicts and obligations those attorneys say make a January trial impossible for them. That list isn't about new evidence or sudden developments. It's about scheduling, workload, and competing cases. Legitimate concerns? Sure. But concerns that belong to the lawyers, not the proof. And that's the final contrast this document leaves you with. One side, you have pages of justifications explaining why delay is more comfortable, more manageable, more convenient. On the other, you have a defendant who didn't sign, didn't agree, didn't ask for more time. And that balance speaks louder than any signature on the page. This appendix doesn't change the evidence, and it doesn't even strengthen the case. It just confirms the divide that's been there the entire time. Some people want to run away. And Durk just wants a jury. He wants a boxing ring. He wants to fight. And when the court looks back at this record later, whether at trial or on appeal, this is where it'll be clear who stood ready and who needed more time before putting their case to the test. But y'all know what? I got a crazy theory that I'm going to run by y'all, and I think I'm going to destroy shit. But since this video been a little bit long, let me give y'all some music real quick to set the theme. Having federal nightmares. I'm having federal nightmares. So this is where the government whole case starts to actually crawl. Because if Durk was actually afraid of this evidence, if text were really the smoking gun, if these lyrics really proved anything, why would he be the only one saying, let's go to trial right now? Just think about that. The same government telling you this case is so fucking complex, right? The same government saying they need 5 more months. The same damn government claiming they already have everything that they need. Right. They're now asking for more damn time. While Durk is saying, no, that's not fear. That's not pressure. Let's be very effing clear. Lyrics are not confessions. Associations are not crimes. And being successful in violent environments does not make you a gang leader. The prosecution wants time because time lets them shape narratives, not prove actual factuals. Time lets them stack lyrics next to actual crimes. Time lets them lean on the cooperators whose stories only work if you don't question them too hard. Durk is cutting through all of that. He said, if you got evidence, I'm going to need you to go ahead and show that. Where they at, though? If you got proof, put it in front of a jury. And if you don't, stop hiding behind delays. And here's the part nobody wants to effing say out loud, Chico. If this was the case, and this case was so damn airtight, the government wouldn't be stalling. They wouldn't be juggling calendars. They wouldn't need exclusions and extensions and goddamn excuses. They'd be ready. So, when you see Durk standing alone, refusing to push the trial back, understand what that really actually means. It means he ain't doing no damn running. He's not negotiating through fear. He's not asking for no damn favors. He's demanding his damn day in court like today. And that's not the posture of a man with something to hide. Because if I was truly, truly guilty, I would be thinking, since I got people directing shit, they're going to try to help me in the background. That's the posture of someone who knows the difference between allegations and proof. Remember that, because where there's smoke, there's fire. But when the smoke clears, this case won't be decided on tweets, lyrics, or vibes. It'll be decided on evidence. And right now, the government is the one asking for more damn time. They're going ahead and hiding it with the damn co-defendants by basically throwing phone books. Some of y'all might be too young to know what a phone book is. So basically throwing books on books on books with a ton of words. I can guarantee you that 30,000 gigabytes of bullshit with 30,000 pages, bruh, probably like maybe 4% to 5% really have to do with the quote unquote meat and potatoes of the whole entire trial. So I'm asking you all this simple thing. Even if you dislike Durk and you think Lil Durk is guilty, why are they delaying it so badly? Why are they allowing it so badly? Because they need actual witnesses that can come in and say some shit. Do not believe the headlines of, oh, there's so many people willing to testify. No shit. You don't think they've been told, hey, bro, we'll speak favorably for you? If it's only 4 people involved and then Durk, the 5th, where the hell did 6 and 7 come from? Why didn't they get on the plane as well? But here's where it really, 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 really boggles my mind. And nobody I've seen ever pointed this shit out, right? If the case is so airtight, so effing airtight, I had to ask you guys this one simple question. Why do we need old ass lyrics from shit that was months and months and months and months and months before? The lyrics actually should not matter. Why are they fighting to bring in lyrics? And remember this before we get out of here. When they first dropped the lyrics, they included a fan edit on goddamn Twitter and YouTube that included Quando Rondo saying no. And then all they said was, oh, well, somebody put OTF fan 600 or some shit like that. And basically said, well, Lil Durk didn't say don't put that shit out there. Think about that. Just think about that. They fought. Then they didn't even know when the damn song came out. So if your case is so strong, your case is so damn strong, why do you need that? Honestly, why do you need that part in particular? I'm really asking y'all. I'm really asking y'all a simple question. Why the hell do you need that in particular when it's an old ass song that damn near was like 7 months before this shit even happened? Then you're tying in shit that has nothing to do with nothing. But maybe I'm wrong. Maybe y'all one of those people who's sitting on the sidelines going, Nash, that shit don't matter. Lil Durk did it. Tell me why. Give me your crazy ass answer, because I'll give you my crazy ass response. And I guarantee you this, you can't bark up this tree and win. Hell nah. A mountain lion climbed down and y'all turn poodle. So don't put in them comments, them weak ass comments like, oh, he's just done. Nah, make some damn sense of it, because I'm willing to debate all of y'all. Because can't none of y'all who say Durk is done defend that shit I just said. Or if you agree with me and you've seen other points that I didn't make them damn points right now. Comment your thoughts, and I'll catch you on the next one. Y'all know exactly where to come to when that Durk paperwork drop. I try to do my thing with this one right here. Hopefully it worked. If you like what we do here, man, and you want to support the channel, like and comment. And y'all know when we get to 300,000 subs, we're giving away the PlayStation and the doggone Xbox. Other than that, I'll catch you on the next one. And click right here for that YNW Melly update. We got court tomorrow too. And in a couple hours, we're going to be dropping a crazy-ass Boosie story. Catch you on the next one.